Evicting a tenant can seem like a complicated process, but in this video, we'll quickly explain eviction laws in Minnesota and how to recover your property in 5 simple steps. First, what is an eviction? Eviction is the process of legally removing a tenant. It's illegal for a landlord to change locks or physically remove a tenant themselves. So, if the renter refuses to leave after violating their lease, you must seek an eviction from the court. The process for simply terminating a lease differs from that of an eviction. Lease terminations require proper notice from the landlord or tenant, and state conditions can be found on our website. Legal reasons for eviction in Minnesota. A landlord only has grounds to evict a tenant for reasons allowable in the state. The first step in the eviction process is to give the lessee one of the following notices. Non-payment of rent. If the tenant is late on rent, you can serve them a 14-day notice to pay or quit. This gives them 14 days to pay the rent in full along with any penalties or vacate the property. There is no statute in Minnesota for lease violations and instances of illegal activity. For these cases, landlords are advised to notify the tenant on their own terms, and if they refuse to comply with the lease, you can move to seek an eviction from the court. Rent grace period. In Minnesota, there is no rent grace period. Rent is due on the due date. An eviction notice can be served if rent is only 1 day late. 5 steps to legally evicting a tenant in Minnesota. Serve the notice to quit. Choose the form you need and download or fill it out on eforms.com. Post it on the tenant's door and also send it via certified mail with a return receipt requested via USPS. If the breach is curable, you must wait for the specified number of days to give the tenant a chance to fix the problem. File eviction papers with the court. If the tenant hasn't mitigated the issue and remains on the property, you can proceed to the district court where the property is located. In Hennepin and Ramsey counties, this will be your local housing court. You'll need to file the following form: Eviction Action Complaint. After filing the complaint, the court will issue you a summons detailing your upcoming hearing. Serve the complaint and summons. After the filing, the tenant needs to be served the information about the case filed against them. You'll need to hire a process server to deliver the documents to the tenant no less than 7 days before the hearing, and you must file proof of delivery no later than 3 days before. Attend the hearing. A decision will be made at the hearing. If the tenant doesn't attend the hearing or if the judge rules in your favor, a judgment will be issued that orders the tenant to vacate. Removing the tenant. If the tenant is ordered by the court to leave and they do not vacate, you may apply for a writ of recovery of premises or order to vacate, which, once granted, will allow your local sheriff's department to remove the tenant and their possessions. Damages. Often the tenant's security deposit does not cover total losses. If damages are not awarded at the hearing, you may be able to recover past due rent and court fees through a small claims court. Now, you can get eviction proceedings started. Get eviction forms, court documents, and all other information you'll need at the link below for free.